state bears the burden of proof. And so the district attorney speaks first in opening and closing argument, and then they speak last. My name is Mr. Kofer. It's been a privilege to represent Kaitlin Armstrong. I'll visit with you a little bit, and then my colleague, Mr. Puryear, will visit with you. When we sit down, Mr. Gonzalez will have the opportunity to speak with you. 1 year, 4 months, and 12 days. That is how long Kaitlin Armstrong has asserted her innocence. And from day one, she asked for this trial. She asked for you to hear this case. You have all done extraordinary work. This is a difficult case. It is an emotional case. It could appear to be an easy case. For those 1 year, 4 months, and 12 days, Kaitlin Armstrong has been trapped in a nightmare of circumstantial evidence. How do you go about disproving a negative? The government has presented you the government's case to meet the government's burden. There is a lot of sizzle. There's not much stake. It's a case based on assumptions, it's based on confirmation bias, and a lack of direct evidence. Let us talk about the case against Kaitlin Armstrong. It starts with jealousy. Jealousy is suspicion of someone's unfaithfulness in a relationship. And jealousy is a type of insecurity. We know that Colin Strickland fostered insecurity, and he has become the new poster child for Peter Pan syndrome in Austin, Texas. So what is the evidence that Kaitlin Armstrong is a jealous psycho? Colin was not honest with Kaitlin about his special friend in Colorado. And Kaitlin allegedly sent him a photograph of that friend. The implication being, number one, perhaps she had been looking at his phone, and number two, that she's crazy and jealous because when he was sneaking off to Colorado to meet up with the person sending him inappropriate photographs, she had the temerity to not like it. Kaitlin called Moriah Wilson once in October 2021. The text messages introduced into evidence show you that she had immediately before been in conversation through those messages with Colin about the location of her helmet. Probably it wasn't a phone call about the helmet. Let's be real. Probably it was a phone call, something to the extent of, by the by, Colin Strickland is a little bit of an ass, and I live with him. Is that so unreasonable? Is that insane? Kaitlin also had the chutzpah to send Colin a snarky text message when there was an Instagram story of Colin in a photograph with Moriah Wilson, undisputed. Kaitlin texted, "Give my regards to Mo." That doesn't make a murderer. It's possible that Kaitlin viewed Colin's text messages, undoubtedly. Just as Colin testified from the witness stand that Colin had done the exact same thing in past relationships. You 14, and the 12 of you who will decide this case, are a relatively unique species in Travis County. You are a diverse jury. You are a diverse jury of age, of gender, of experiences, and of race. That is uncommon in this county. I want you to bring that diversity of life experience into your deliberations. I want you to look out at this assembled audience, and I want you to wonder, because generations are different. This morning, someone advised me of a new app the kids are on, Flip. Hadn't heard of it until this morning. Young people communicate a little bit differently, but I would bet you every penny that I am worth that at least one of you has looked at your partner's text messages at some point. And I would bet you everything that I'm worth, and him, that that's true of a number of the people that are in this audience. And the younger they are, the more common it is. Because jealousy is a fundamentally human emotion. Because it is about lack of trust in a relationship. But we know what Mr. Strickland shared with us about Kaitlin Armstrong. That in October of 2021, when Colin Strickland was having his short relationship with Moriah Wilson, that Kaitlin Armstrong was on dating apps. That Kaitlin Armstrong was dating other people. We know that Colin Strickland told you that at the cyclocross events in Bentonville, Arkansas, in January of 2022, that Kaitlin didn't appear to him jealous in any way. Nothing remarkable about her behavior to him. And in fact, we know that he shared that, yes, he'd had a long-standing sexual relationship with professional cyclist and woman, Amity Rockwell. And that Kaitlin was friends with Amity Rockwell. That Kaitlin had never expressed anything approaching jealousy or negative emotions about Amity Rockwell. Moriah Wilson was not the first cycling woman in Colin's life. Colin hid his relationship with Moriah Wilson into 2022. He did that because he didn't want to be honest about it. He doesn't like emotions. He likes what he wants and what's important to him. He was breadcrumbing, and I think you know what that is. He was leaving his options open. He just didn't want to get caught. He didn't lie because Kaitlin was a jealous psycho killer. He lied because that's how he approaches life. That's how he approaches women. He's a professional cyclist and an amateur liar. Well, what did Colin Strickland say about Kaitlin, though? He said the relationship was not volatile. Kaitlin was not a particularly jealous girlfriend. He shared he'd had girlfriends in the past before Kaitlin, and that Kaitlin was not jealous like those other past girlfriends. Who brought up jealousy first? Austin Police Department Detective Richard Spittler. On May 12th, mere 12 hours after the murder of Moriah Wilson, when Detective Spittler interviewed Colin Strickland, who first said that J word, Richard Spittler, because it was a great theory. And what a convenient narrative. What a wonderful and easy way to paint a woman and to tell a story. The woman scorned. Whether the facts met the narrative or not, it's a great story. The truth of the matter is that Kaitlin's emotions and her actions were normal and routine and human. But she had to be portrayed as a jealous psycho to create the motive. The problem, however, in Colin and Kaitlin's relationship was not Moriah Wilson. The problem was always Colin Strickland. However, Colin's behavior does not make sense. Colin changed Moriah Wilson's name in his phone on May 11th. Colin deleted his text exchange with Moriah Wilson on May 11th. What was different about May 11th? Why did he do that on May 11th? He felt he needed an alibi. Why that day? Jealousy. But what about the black Jeep? You know exactly where and exactly when that Jeep traveled. There is not a doubt that Kaitlin's cell phone was on her person between about 5:30 p.m. and at least 7:30 p.m. on May 11th. There's no dispute whatsoever as to that. And there is no doubt of any type that Kaitlin's cell phone was in the vicinity of the black Jeep. Was Kaitlin in the black Jeep? Who had access to the black Jeep? Who had access to the key fob to the black Jeep? Who had access to the key bowl containing that fob that drives the black Jeep? Who previously owned a black SUV? Pam Mazak presented you a compelling PowerPoint. Animation, details. PowerPoint presentations in criminal cases like this are a lot like swimsuits. What they reveal is interesting. What they hide is what's essential. It's real easy to look at the animation that Pam Mazak provided you and see dot, 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 call, detail, record, timestamp, dot, 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 dot. And then to see infotainment, track log, dot, dot, dot. And if you don't review the data, if you take it on the word of a PowerPoint animation, it's really easy to look at it and go, the phone was in the car and it was riding together. There is a very, very good reason that you were shown a PowerPoint and that you were not presented the data. When you return to the room back there to deliberate, ask for the PowerPoint, ask for the actual data. The problem isn't the data in your heads. The problem is the presentation of it. Because what you'll see, if you actually look at the data, is that you were left with an impression that is not true. Look at the timestamp on the call detail records compared to the infotainment. And you're going to see a lag. And sometimes you'll see an advancement. And what you'll see is that while it is undisputed that the phone was in the vicinity of the black Jeep, you'll see that there is zero conclusive evidence that phone actually was in the black Jeep. What you will see, though, is some really peculiar movement of the black Jeep. Peculiar movement that Pam Mazak completely skipped over. When that vehicle is heading northbound on Lamar and stops near an area called Spa 7, where maybe somebody had an appointment, or maybe not, you're going to see some very strange movement of the data within a parking garage. And you might wonder why that car may have gone up and down inside a parking garage, and why when the car is moving inside a parking garage, the phone is not in that parking garage. The phone is inside of a building. What about all those other vehicles? What about Colin's mom's car? What about the Mercedes? What about the trucks? What about the half dozen odd vehicles? Did Kaitlin Armstrong have access to vehicles that weren't the black Jeep? Absolutely. Did she drive vehicles that weren't the black Jeep? Absolutely. But wait, Rick Kofer. Colin said, I saw her get out of the black Jeep. But that's not what he said. The first time he testified in front of you, a few weeks ago, it was a Friday, he said that's what I believe. He was real hesitant. He wasn't rock solid. Then he had a weekend to think. And he came back and he continued to testify in front of you on Monday. And somehow his memory and recollection of every detail in this case had become fuzzier between Friday and Monday over the weekend, except for his opinion about seeing Kaitlin come out of a black Jeep. And when he sat on the witness stand and testified yesterday, somehow all of his recollections had become even fuzzier still, except that he claimed he saw Kaitlin Armstrong come out of a black Jeep. How amazing that the one fact that he seemed to remember with greater clarity over time was the single fact that drew attention away from him and pointed the finger at Kaitlin Armstrong. We're to believe this, that that's what he said, that that's what he actually saw. From Colin. Colin, with his marked lack of interest in Caitlin's life. Colin, who on May 12th said that Kaitlin had arrived home mere moments after he texted her at 9:21 p.m., 6 minutes after the killing of Moriah Wilson. Colin, who couldn't recall a single detail about Caitlin's behavior that night, that does not make sense. And Colin may have had other reasons for saying what he did. Remember, Richard Spittler did not believe that Colin was truthful and forthcoming. What about those guns? Colin bought those guns. Colin told her to train with the gun. And she did. Once. And she was totally normal. I asked the witness, Jill, did Kaitlin seem all murdery? No. Now, the prosecution led with a video of her at the gun range. Raise your hand in the audience if you've ever been to a gun range or ever held a firearm. Did you kill anyone? It's emotional. It's compelling. But that's a rabbit hole. That's a smokescreen. But what's peculiar is that Colin sat up here on the witness stand and said, oh yeah, no, that cable lock for the gun, yeah, that was mine. I have no idea where the second cable lock came from. He had no problem admitting that he owned a cable lock before buying guns. He had no problem admitting that he owned a red cable lock on a Smith & Wesson, which appears unaffiliated with this case. But when confronted with the evidence, I have no idea where this black cable lock on the black Sig Sauer came from. And when we invited him to come and demonstrate to you, to stand here, to show you how a cable lock works, suddenly Colin Strickland, engineering degree, Colin Strickland repairs and sells Spartan motorhome trailers. Colin Strickland, the mechanically sophisticated man, suddenly he has 10 thumbs, and I don't know how this works. Bullshit. He wasn't straight with you. He knew exactly what that cable lock was, and he knows exactly how it works. And the reason that he was blowing smoke to you is because he did not want you to see that the usage of a cable lock is no easy feat. To rack the slide, to eject the magazine, to then replace it. And so Colin wanted to leave you with the impression, I don't know. The black, I have no idea. The thing from the murder, I don't know. And yet somehow Kaitlin Armstrong, who it appears at best, had in her life held a gun one time, somehow knew to use, to remove and then reattach a cable lock. When you heard from Jill from the witness stand, Kaitlin didn't have any experience with that. When they went to the gun range at Colin's direction, there was no cable lock. How did the cable lock get on the gun? Colin says he didn't do it. We know Kaitlin didn't do it because Jill said so. That does not make sense. But Rick, what about the DNA, Rick? Kaitlin cannot be excluded as a potential contributor to a DNA swab from Moriah Wilson's bike. Period. Full stop. A swab from the handlebars and from the seat of that bike. I am no DNA expert. None of y'all are either. We heard from several of them. I don't know. I know that there's transfer DNA. I know that there can be lab contamination. I know that there was a lot of conversation about helmets and who wore what helmet and when they wore it, and if we know who wore the helmet when and this and that, or did Colin put on a black motorcycle jacket as he discussed with Richard Spittler on the way from Caitlin Cash's apartment to Deep Eddy and Poolberger? Would that black jacket have his DNA? And then if Moriah would with Caitlin and the, I don't know. You will make of that what you will. But the upshot is this. There are two realities. Schrodinger's cat. Either Kaitlin Armstrong was there, and that's why there's DNA that was found on that bike, or at least that she cannot be excluded, blah, blah, blah. Or a person wearing gloves had their hands on a driving steering wheel that had Caitlin's DNA. Or Moriah Wilson had touched the same bike, or the same helmet, or the black jacket. I don't know. But I do know one thing. Every person that handled this bike handled it in the same way. It was arm day at the gym this morning, and this is still really easy because this is how you pick up this bike. But what the government and the police would like you to believe is that after a brutal slaying, that the way, and see how this tire is arranged, that the way then, Kaitlin Armstrong would have, I guess, wanted to hold the bike like this. That does not make sense. Everyone held it this way. And what's astounding, and this is what you heard from the APD expert, right here, on this portion of the bike frame, this was the area not swabbed for DNA. Why not? It was more appropriate for latent prints. Could you have swabbed for DNA? Absolutely. Why didn't you? It was more appropriate for latent prints. No DNA here, but why would anyone That doesn't make sense. But what about the missing DNA analysis? No analysis of any DNA from that bike frame. What about the swabs taken from the black Jeep? You heard testimony. DNA swabs were taken from inside the black Jeep. Never tested. Why? Why not? Why leave it to chance? What if it had shown yet another unknown profile? How inconvenient. We do know, as a fact, unknown DNA profile on the seat, unknown DNA profile on these handlebars, unknown DNA profile on the gun. That does not make sense. Austin American Statesman got it right. There's mystery DNA. And there's one more source of DNA that was never tested. The rape kit. The truth of the matter is, Austin Police Department did not want a single piece of evidence in front of you that might point away from Kaitlin Armstrong. They didn't want any evidence that could potentially be inconsistent with their version of the case. And that's why the black swabs from the Jeep, or the DNA swabs from the black Jeep were never tested, and that's why the rape kit was never tested. Rick, what about the police interrogation? We saw her on the video for 11 minutes. She looked cold, she looked bad, she looked like a killer. Imagine that your boyfriend has just been contacted by 2 homicide detectives and told to come down to homicide. And that not but 60, 90 minutes later, additional law enforcement arrives, tactical vests, guns. You're under arrest. What am I under arrest for? Don't know, can't tell you. And then you're taken down to be interrogated, put in a room with Katie Connor, who may not be the worst homicide detective I've ever seen, but is certainly in the running. And told, oh yeah, you're under arrest on this warrant. I couldn't tell you a thing about it. I don't really know. Oh, is someone knocking? No, no one's knocking. Oh no, I think they're knocking. Kidding. Our bad. You're good to go. Hey, your boyfriend and the... What would you do? How would you respond? Don't you think you'd be a little confused? Rick, come on. Costa Rica. What are you, an idiot? Come on. She ran. She ran. Only a guilty person would run. Are you a fool, Rick Kofer? And yet you heard testimony that Kaitlin was told by the Austin Police Department, free to go, ma'am. And when she went to New York, free as a bird, just like any of the 14 of you. And when she booked that ticket for Costa Rica, when she drove to Newark Airport, when she got on a plane bound for San Jose, what did Richard Spittler tell you? That the murder warrant that he had gotten about 10:30 p.m. on May 17th, 2022, had not been entered into TCIC and CIC. At the moment she bought that ticket, at the moment she was on the way to the airport, on the moment she got there, when that plane was taken off, there was no way in the world that Kaitlin Armstrong could have had any awareness or knowledge in any way whatsoever that there was a warrant for her arrest. But we do know that Kaitlin Armstrong routinely traveled internationally. We know that she routinely traveled internationally with little notice. There were multiple witnesses who testified to that. And we know that she did it related to her yoga. Was she scared? What do you think? Do you think that she may have been concerned a little bit that her boyfriend had killed someone? Or if not that whoever killed Moriah Wilson might want to kill Kaitlin Armstrong next? Or that this might have been connected to the vandalism, the unexplained vandalism outside her house? Fear. Fear results in fight or flight. And it was flight. And she certainly was afraid, and that's a reasonable conclusion you can draw. Rick, a couple of weeks ago, she ran away. They took her to a medical appointment, and she ran away. Guilty. Why are we even here? Terrified woman, fearful woman, in jail, abused, injured, someone who doesn't know what they're doing.
There's been no testimony about the things he's talking about now.
I'm moving on.
He can twist the evidence any way he wants to, but he can't try to add new evidence.
Ladies and gentlemen of the jury, recall the evidence as they heard it from the witness stand.
That's the case against Kaitlin, right? Isn't that what it boils down to? Did I miss any of the big points? Isn't that where we're at, that circumstantial evidence case? It's a simple case. It's an easy story. It's a beautifully simple story. But it's wrong. And it's based on assumptions of gender and of motive and a bias toward confirmation. And who got to investigate this? Richard Spittler on his first homicide. Why test a rape kit? Why would I need Colin's laptop? I looked through it. I mean, sure, I've got no background in digital forensics, but I looked through it. It seemed fine to me. Let's return it to Colin. One single solitary piece of physical evidence has been removed from this case. Colin Strickland's laptop. Why was Richard Spittler so eager to get Colin's laptop back to him? Why does Colin get treated differently than everyone else? What about Colin's iPad? Why was it never seized? Why was it never extracted? Why didn't Richard Spittler bother to contact or investigate any potential suspect until months and months after he had issued an arrest warrant for Kaitlin Armstrong? He calls Alan Lim, a putative lover of Moriah Wilson. He calls Gunnar Shaw. Surely he did that in the days after the murder. No, he did it in July. And he did it, as he said, because he doesn't know what the defense is going to pull. Guess what? Alan Lim didn't kill Moriah Wilson. Gunnar Shaw didn't kill Moriah Wilson. Did Richard Spittler know that on May 17th? Nope. He didn't even know their names. That was the level of his investigation. The vandalism, the video that you saw yesterday, where Richard Spittler is energetically taking notes, what happened to those notes? where Colin Strickland is showing the photographs of that vandalism, what happened to those photographs? Richard Spittler thought so little of it that he violated Texas law, that he refused to provide this district attorney's office that report. He refused to conduct a single scintilla of investigation. Why? That didn't really fit the narrative, did it? So why look into it? Why would it matter? He didn't test the DNA from the black Jeep, but he did go and get an arrest warrant based on hearsay and innuendo and anonymous phone calls. He didn't even bother to watch the 11-minute interview of Kaitlin and Katie Connor. He claimed that there was a NIBIN investigative lead when there was none. But we know one thing, he testified he knew Colin from before. What a world to be treated like Colin Strickland has. So what happened here? Police think Kaitlin committed this crime. They don't know. She fits their story. She fits the story they created. A spurned, jealous lover. That story is so easy. That story is so easy to tell because it ties into a framework of patriarchy and misogyny that is rooted in American culture. Humans want to know answers. We don't want a mystery. That's part of why wrongful convictions occur. Michael Morden, Greg Kelly, what exonerated them? DNA. So if Kaitlin Armstrong did not kill Moriah Wilson, who did? I don't know. What a terrible answer. A much better lawyer than me, Bill Fitzgerald, was asked that same question in the Michael Morden trial. If Michael didn't kill Christine Morden, who did? His answer, I don't know. And the reason that answer is so unsatisfying to you is because we as humans demand closure. We demand explanation. A mystery ruins it. And someone had to sit for 30 years in prison before the real killer of Christine Morden was found, and then that chapter was closed. But we do know a few things. We know what Colin Strickland actually said, that he considered Kaitlin to be an incredibly kind, caring, and sweet person, that Kaitlin had only shown absolute above and beyond examples of human compassion and thoughtfulness and care and going far out of her way to help others. Colin said, Kaitlin is a mild and gentle person. Colin said, Kaitlin is not a particularly needy person. Colin said he could not imagine Kaitlin hurting anyone. Kaitlin had never done anything violent in her life, according to Colin Strickland. Kaitlin had never been violent, says Colin. How did Colin sum her up? Kaitlin was a softie. So what happened? Anyone could have entered that unlocked apartment. Why was it unlocked? Moriah Wilson locked the door to Kaitlin Cash's apartment when she left to go out with Colin. She knew how to lock it. She did not lock the door when she returned. Was she expecting Colin to come back? Was she expecting someone else? We will never know. Detective Spittler, Detective Connor, the Austin Police Department flubbed this case. But I guarantee you one thing. If you convict Kaitlin Armstrong and she's eventually exonerated, you'll know right now the basis of it.
Yeah,
Untested DNA.
That is inappropriate argument.
Stop, there's an objection.
That is inappropriate argument to the jury. to somehow imply that they might make a mistake and then come back to harm. That is improper to put that kind of pressure on them.
Any response to that?
I have no further argument.
The objection sustained, the juror will disregard that remark, counsel.
Mr. Puryear will join you now.
I don't know. I don't know. A guilty verdict, proof beyond a reasonable doubt, means putting the I don't knows that you have in a box, moving them aside, and pretending they don't exist. The I don't knows that you have are something you need to start thinking about. This is the time to do it. Those I don't knows are important. I don't know why Cash's apartment was unlocked. I don't know that. I don't know why Mo was clutching a black baseball cap 45 minutes after she got home. I don't know that. I don't know why Colin lied. And I don't know why he lied about lying. I don't know that. I don't know why Detective Richard Spittler didn't test the sexual assault kit. I don't know that. And I don't know why he didn't test the swabs from the black Jeep. I don't know that. And you don't either. And that is the whole point of this trial, is that those I don't knows are important. And it's easy to disregard those I don't knows. It is easy to swipe those off the table, right? And just accept Detective Spittler's version of what happened. Just to accept that narrative, right? That's the easy thing to do. But while jury service, the service that you're doing right now, is a privilege, it's also a duty. It's not supposed to be easy. It's not easy. It's difficult. But that's why you're here. That's why you're here, and you're here, and you're here, and you're here. Because way back, weeks ago, when we were talking in jury selection, we observed you to be thinkers. We observed you to be gripped with the courage to ask the tough questions. We observed you to be willing to set aside your basic assumptions about what it means to be accused of a criminal offense. That's why you're here. And it's not easy. It is difficult to ask those tough questions. That is difficult. To address those I don't knows. That is difficult. But that is why you're here. Let's talk about DNA. You heard from at least 3 experts about DNA, and you heard a lot of different perspectives about what DNA is, what it means. But one thing that they all agreed on is this. DNA means that a clump of cells was found in the exact spot that they were collected from. That is what DNA means. And we have a tendency to mythologize DNA, right? From what we see on TV, from what we see in the movies. We have a tendency to mythologize it, to put it on a pedestal as meaning something that it doesn't. DNA is an artifact, just plain and simple. Now, I think what you've seen, despite what Dr. Calfett told you yesterday in court, is that it doesn't confer a crystal ball on anyone. It doesn't confer on anyone a time machine. The ability to go back in time, like a Christmas story, to revisit things that happened from an observer standpoint and be able to create a narrative from it. It is not scientifically defensible. It's just not. The state's own expert, Samantha Perkins, testified that you can't fabricate the kind of narrative, the kind of probabilities that Dr. Calfett wanted you to believe he can create in his mind simply from the presence of DNA. All DNA is an artifact. That's it. That is the scientifically defensible position to take. Now, Dr. Calfett wanted to take it a step farther, right? To write the script for you, that is not scientifically defensible. And their expert acknowledged that. It's just not. Ballistics, let's talk about that. Now, I think, despite the length of the testimony, Steve Aston and Bill Tobin, I think, agree on a lot of things. There's a lot of overlap in the position that they take. Now, Bill didn't get up here and tell you that it's junk science, that it's ridiculous, that it's preposterous, and bring a bunch of conspiracy theories to you. No, he didn't take that position at all. In fact, he worked at the FBI. He worked side by side with those examiners for more than 20 years. He wasn't here to tell you that it's just junk science, that it's completely unbelievable. Quite the opposite. That's what you heard. And I'm going to disagree with the state's characterization of his answer on that last question. He didn't say, I absolutely agree with Steve Aston. I absolutely agree with his opinion. Sure. 4 hours wasted. If that was his opinion, it would have lasted 5 minutes. That wasn't his opinion, and you're smart enough to recognize that. His opinion was Steve Aston is entitled to his opinion. He's entitled to tell you what he thinks it is. He doesn't agree with it. But it's a subjective science. It differs from person to person. Of course he's entitled to his opinion. Every firearms examiner has their own opinion. It is subjective. That's the whole point. That was the whole point of his testimony. He didn't doubt Mr. Aston's ability to make very experienced observations about tiny lines that may be present on shell casings, on bullets, on projectiles. But just like their DNA expert, Dr. Calfett, Steve Aston wants to take it a step farther, to go beyond the science, right? To be able to say, this gun fired this bullet, this gun ejected this shell casing. To make it say things that it doesn't say. Mr. Tobin recognized the limitations of what ballistic science, what firearms and tool marks examination can say. And what is that? That based on Mr. Aston's examination, it is consistent with being ejected from that gun. That it was possibly the source of the fired cartridge casings. Possibly. And guess what? That is exactly the language that you'll see in the DNA report. That it can't be excluded. That it is possibly the source of those shell casings. That it's possibly the source of those projectiles. Now, Mr. Aston wants to take it a step farther and say, this is it. We got it. That is not scientifically defensible. Now, I know what you're going to say. Mr. Puryear, you guys paid Mr. Tobin to come in here and say all those things. He's a hired gun, right? Fine. Don't take his word for it. Disregard everything he said. Disregard his opinions. Take that off the table. But I'll be real with you folks, I don't have the juice or the disposable income to convince two separate groups of the most preeminent scientists the United States has to offer who agreed with his position. I don't have it. I wished I did. I don't have the pull or the ability to go back in time to 2015 and talk to President Barack Obama and convince him of his legitimate concerns for the limitations, the reasonable limitations we can put on that field of forensic science, who had concerns about setting boundaries for the kind of unqualified, reckless opinions that Mr. Aston offered you in court. I don't have that ability. Now, I can tell you that our president, back in 2015, had those concerns. I can tell you that those groups of scientists had the opinion that individualization, that ability that Mr. Aston claims to have, is not supportable by relevant science. That was the opinion of the brightest minds, brightest scientific minds this nation has to offer us. That was their opinion. Don't take Bill Tobin's word for it, but you can trust that group. Now, he has a job. Steve Aston has a job because he claims he has that ability to come in here to court and say, this gun fired these bullets, right? That's why he has a job. There's not a detective or a DA's office in Texas that has any value for an examiner that's going to come in and say, this gun is consistent with a production lot of 2,000 other guns that could be the source of those bullets and casings. Not a one, right? His testimony is consistent with keeping his job. Testimony like that isn't what the police want to hear. Let's talk about Kaitlin's interview. Why she reacted the way she did. Why she requested an attorney. How much trust would Kaitlin have in the competence or professionalism of the Austin Police Department after that experience on May 12th? She's arrested on a silly minor charge in front of her house, in her neighborhood, dragged into the station. Then she's escorted into a room, and she's told, we need to read you your rights. This is a very important situation. She's never read her rights. And then they come in and say, oops, sorry. No warrant, just kidding. But hey, stick around for a few minutes. And then they come back later on and say, oops, we goofed again. Turns out you do have a warrant. How much trust would you have in their competence? Put yourself in her situation. If that's me in that room, I'm looking around for game show cameras. Is this a joke? This can't be real. That is what you heard. But what else did Katie Connor tell you? That Kaitlin on that day, the day that she left for New York City, the day that she left for Costa Rica, she was as free as you or I or Detective Katie Connor to fly across the country, to fly out of the country, right? That's what you heard. So it's easy to say she fled. It's easy to say that. That is not what the evidence supports. She was perfectly able to go anywhere she wanted to, and from a deeply ingrained primal place in our brains, when faced with fear, when faced in a stressful situation, like my colleague said, what do? It's fight or flight. That attempt to retreat, to find a safe place, to find a place of comfort. And she's not alone in that. Colin did the same thing. Colin went to his dad's house. That's a place that I felt safe. That's a place that I felt comfortable. That's a place that I felt good. That's a natural reaction. And it's easy to say, well, I would have done something different. It's easy to project what you would have done on somebody else. We all react differently to stressful situations. Now, I want to talk to you about some other things that we talked about. Do we believe that David Harris killed Mo Wilson? No, we don't. Of course not. The point is, there was no investigation into him at all because Detective Spittler had tunnel vision and he jumped to conclusions. Now, the government wanted to imply that this is a red herring, a rabbit's trail, a smoke screen, to ask any questions of Detective Spittler about the failures of his investigation. That you should just disregard all of those things.
Excuse me, counsel. I think some of our jurors have urgent needs, so we're going to take a brief recess.
Yes, Your Honor.
And just remember where you are right now.
Yes, Your Honor.
We'll be in recess for 15 minutes, maybe. Maybe y'all take care of you.
What would be the evidentiary value of a forensic analysis of that rape kit, the sexual assault kit that was collected? I don't know. We will never know because Detective Richard Spittler, didn't care. He didn't care enough to get it analyzed because he determined it wasn't important for you because he had tunnel vision and he jumped to conclusions. What would have been the evidentiary value of an investigation of the criminal mischief that happened at Kaitlin and Colin's house? I don't know. We'll never know because Richard Spittler didn't care. And because he determined that it wasn't important for you. Because he had tunnel vision and he jumped to conclusions. Now, we've all done hard work over the last 3 weeks. The state has too. Your job has been the hardest. And never was your job more difficult than maintaining your attention through the testimony of Detective Portnoy. My gosh. But what did he tell you? What did he tell you? That it was extremely irresponsible of Detective Spittler to return that laptop to Colin after just a cursory glance through it. That was extremely irresponsible. And he did so with really no direct evidence or really any evidence at all to exclude Colin as a suspect. He just did it. How easy would it have been to prioritize a download of that laptop, to have Detective Portnoy do it? He didn't do it because he had tunnel vision on Kaitlin Armstrong and he jumped to conclusions. Folks, trials like this are inherently difficult. A young girl's life was taken. That we have no doubt. And that is tragic. We can all agree on that. And you've heard things and seen things throughout this trial that understandably create strong emotions, that pull on your feelings. And the easy path is to let those emotions sway your decision, to let those dictate your decisions. To let emotion stand in the place of reason and common sense. That is the easy path to take. But the oath you've taken as jurors necessitates that you have the fortitude and the conviction to use your minds, not your hearts, as you analyze the evidence that was presented to you, and more importantly, the evidence that wasn't. When we say, I don't know, we're tempted to mean that we're unintelligent, right? Or uneducated. When we say those words, I don't know, it may even mean for a moment that we're confessing that life sometimes just doesn't make any sense, right? But that is what a not guilty verdict means. It means, in plain terms, we don't know. Not for sure. Not for sure. Not guilty doesn't mean innocent. It can mean something different, right? And we've talked about that. If you say not guilty, you're saying as a group, as an individual, we don't know for sure. And in most real-world situations, saying, I don't know, that's not an acceptable answer, is it? To your boss, to a client. That's not acceptable. It is in the jury room. It is. And don't feel like you failed if that is your conclusion. Because again, the oath that you've taken as jurors compels you to say that if it's appropriate. Don't feel that you failed. In fact, it is your obligation to say those words if you believe they're true. You must only convict if there is proof beyond a reasonable doubt. And if you have doubt, and quite frankly, in this case, you must, then it is your obligation to come through that door and stand before us all and say in substance, we don't know, not for sure. Thank you, Your Honor. Folks, in this life, we know a lot of things beyond a reasonable doubt, right? That Austinites love salsa, that we love our families, that it's raining when those rare drops fall from the sky, right? That the sun rises in the east and sets in the west. We know all of those things beyond a reasonable doubt. We know them to be true. But that Kaitlin Armstrong is a murderer, that she committed this crime, do we know that? Are you certain? Do we know that for sure? Find her not guilty.